U.S. immigration attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions, and I have a good topic for you today. Someone in the comments had asked to talk about holding an application in abeyance. And this is very much related to the VAWA process. Now, when we say hold an application in abeyance, what we're talking about is holding one petition, so holding the adjustment of status application that was attached to a marriage based process, holding it in place and switching that adjustment of status application over to your VAWA application. Because what usually happens here is that the marriage based process is no longer working, and you have because of mistreatment. So the marriage-based application process, you're unable to move forward because it's just not working anymore, right? You can't work with mistreatment. You can't work with the mistreatment that's occurring, and so you need to switch to VAWA. And because of that, we do have to write what's called an abeyance request letter to the office that's currently processing the adjustment of status application, to inform them of this circumstance and to request that they hold the application in abeyance until the VAWA petition there's a decision in the VAWA petition. So when I use that term, or when this person asks me to talk about this, it's basically switching from the marriage-based green card process to VAWA. So let's talk about that process. Now that I've simplified it, so you know what that terminology means, because it's just one of the processes that we have to do when we're going from the marriage-based process to the VAWA. Now, let me give you a scenario here to let you understand how this works. So, if you're in a marriage and your spouse and you went ahead and filed for adjustment of status, you were looking forward to getting your permanent residence through your marriage. You may have seen the red flags before, you may have experienced mistreatment before, but you still had hope that your spouse was going to bring you through the process and to your green card, right? But then, say your spouse starts to mistreat you during the process, or they've always mistreated you, but now you've had it and you are ready to move on. You're ready to empower yourself and move away from the spouse and take control of your situation. At that point is where you need to consider whether you're going to switch to your own VAWA process. The VAWA process is very confidential. That means you take ownership of your application process. This spouse, now not only spouse, by the way, but a spouse, a parent who's mistreating you if you're under 21 or under 25, or if you're going through a parent-child application and your child who's 21 or over is mistreating you, you can also apply for this. So just to let you know, it's not just limited to the spousal relationship. I mean, a huge chunk of applications under VAWA do go in because these kinds of mistreatment is common in marriages, but it also can occur in other type, the parent-child relationship. So keep that in mind. Is if you're you're in a parent-child relationship and your parent or your adult child is mistreating you, this is for you as well. So, say you're going through the process, and when you go through this process, you're being mistreated, or they start to mistreat you, and you're fed up, you're ready to move on, or you just know based on how they're treating you that this is not going to work. They're going to sabotage your process, they're not going to complete the process with you. At that point, that's where I usually get to talk to individuals who are in a situation like this. And this is where switching to VAWA is going to be the solution. And I do suggest that you don't wait for it to get to crisis level. Now, crisis level is where you went to the interview, and it's at the interview that this spouse who's mistreating you they're now dropping bombshells on you. They are bombshells on you. They're telling the officer all sorts of things. They're maybe all of a sudden they can't remember important facts in your marriage because at the end of the day, their goal is not to see you get the green card. I suggest that you don't make it get to that point, because if it does get to that point where they go to the interview and they do this, then you have now a complex matter. Because once the accusation of fraud is there, or once the officer does not believe your marriage is real, you're going to have to work a lot harder to be able to establish that you qualify for VAWA. And they're also going to question your credibility in the VAWA application. So if you know it, when you're being mistreated, you know it. There's no denying it. If that is happening to you and you know that this spouse is capable of sabotaging you or accusing you or calling immigration on you, then it's time to protect yourself and take VAWA into consideration. Because when it gets to the crisis level where you've gotten denied because the spouse did not, they purposely didn't present themselves properly at the interview, they didn't show up at the interview, or they start to tell the officers. I did have one client whose spouse was under the influence of, they were a drug addict. And they went to the interview, and by the end of it, he is under the influence. So he's telling the officers all sorts of untrue things. And so now the officers walk away with an impression that their marriage is not real, right? So you have to think ahead. Don't just go, don't wing it. This is not a situation where you should be winging it. Think ahead, anticipate, and choose the best option in your best interest. So in the case, though, that you do switch, and specifically with situations like this where it's now an emergency, and we file the VAWA petition, we have to then, if an interview is scheduled and maybe the spouse is now saying they're not going to the interview, they don't want you to get your green card, then at that point, when we file the VAWA, we then have to contact the office that scheduled the interview and let them know that our client has filed for VAWA and they will not be attending because now this is a VAWA matter. So what they need to do is hold the adjustment of status application in abeyance. This is where the fancy term comes in, to hold it in abeyance until there is a decision on the VAWA. Now, the benefit of this is that when you hold it in abeyance, you basically preserve your adjustment of status application, your work permit that you may have already or that's pending, your travel document. Everything can keep moving forward. You can continue to renew those things without your adjustment of status application being denied. And so while the VAWA petition is pending, you can continue to work, you can continue to travel on your travel document, and you don't have to worry about the stress of starting over a whole process. Because the VAWA is going to take some time to get a decision on. But in the meantime, you're able to carry on with life as usual. So that is where switching from the marriage-based process before it gets to crisis level, or before you get denied on an adjustment of status application, is beneficial. Switching from marriage to VAWA is that you still get to maintain your adjustment of status application, your work permit, your travel document. You get to renew those, you get to keep those. If you haven't received them yet and you switch to VAWA, you will get that work permit and travel document without any interruption there. So this is where we work hard to make sure that if it's a situation where your adjustment of status is at risk and you're being mistreated by your spouse, that we can hop on it and put the request in place to hold your application. Don't make a decision on it until that VAWA is decided. But it's important to get the VAWA in ASAP, because if you don't have the VAWA in, they're not going to put a hold on that adjustment of status application. The other benefit of holding the adjustment of status application in abeyance is you don't have to spend the additional money refiling your adjustment of status application. And then it also serves as an explanation to the office that something did occur, something happened in the marriage that you now have to switch to VAWA. But at the point where your application is now denied, so you've gotten a straight up denial. Now they have on file that they don't believe your marriage is real, or for one, usually they're going to deny a marriage base because something happened at the interview or something happened in the paperwork that they don't believe your marriage is real. And they will walk the line they'll walk the line, not necessarily say the marriage fraud term, but whenever they're saying they don't believe it's real, you do also have the risk of facing marriage fraud accusations. So it's not to say that even if your application is denied, that you can't apply for VAWA. Definitely not. VAWA is going to be your option here. It's just that it's going to be a little more complex and a little more hard work to present the information to the officers, showing that the previous denial was not necessarily that the marriage wasn't real. It's just that at the time you're going through the marriage, you were being mistreated, right? So that in a nutshell is what holding an application in abeyance is, basically switching from the marriage green card or the family-based green card to VAWA. And VAWA then becomes your own process. It's confidential. You get to continue on with your work permit and your immigration benefits, like the work permit, travel document, the ability to stay here until that VAWA decision comes in. When the VAWA decision comes in, then they move right on ahead with the green card process. So that's where the switch is also beneficial, is you don't have to refile an adjustment of status application. Once the VAWA petition is approved, you move right on to the green card process. You get your 10-year green card based on the mistreatment by a spouse, a parent, or an adult citizen child. All right. So now that I've said my piece, I'm going to jump to questions. Now, I did put in the comments. I don't know if you're able to scroll back and forth, but I did put in the comments more towards the top, the phone number. Take note of that phone number. Give us a quick call to talk to staff. And if you don't have the time to call, but you do want to get on my schedule, go ahead and go to the link in the profile. You'll see a button on that link. It's Linktree. Look, one of the links is going to be to schedule your own appointment. Go ahead, schedule your own appointment and let us get started. I would like to help you, and my schedule is filling up. So please make sure you get on my schedule so I can help you, because there's nothing more fulfilling than being able to help people to get out of situations that they felt they could not get out of, or that they felt they didn't have options, and now they do. So go ahead, give us a call, schedule an appointment. Let's talk through your process, make sure that you qualify, and then we get started right away. All right. So questions. Hi there. So quick question. I have filed my VAWA 11/21/22 and I've received prima facie. Congratulations. Haven't done biometrics, but they requested for my medical and submitted. How long should I wait for the work permit? So the medical is related to the adjustment of status application. Now, if they approved your VAWA petition, which it's usually, if they've approved it already, great, but it usually doesn't, the decision for the VAWA doesn't come so soon. But at the point, the medical is really going to come into play at the point where you get approved for the VAWA and they're now in the green card phase where they're processing your green card. Depending on how much time goes by, they may ask you to provide another medical if it does expire. So keep that in mind. The work permit is taking anywhere from 9 to 12 months to come. How do I know my VAWA case is approved? You'll get notification. So you'll get notification by mail, and sometimes they'll update it on the website on the case status as well. If you use your receipt note number and look it up on uscis.gov, you'll see that maybe your I-360 has been approved. That's the name of the form. Or you or your lawyer, because what we do is we collect the notices, and we're in charge of monitoring correspondence for our clients because that's a part of our representation, is to make sure that we are communicate directly with the USCIS. But we also do it to ensure that we are the safe address for our clients. That means that if they're still living with this abusive spouse or relative, or they're the relative who's mistreating them, that they will it stays confidential, and that we correspond with our clients to be able to exchange those important documents in a safe way for them. Hi, good afternoon. If a marriage takes place after a child is 18, can that child be added to your VAWA application? Yes. So now at the point, now the derivatives on the VAWA is not going to depend on your marriage to that citizen or resident. It's going to be dependent on the child's age. And as long as they're under 21, they can be added to your VAWA application. I'm scrolling through looking for questions. So put those questions in the comments so that I can answer your questions now. So in the comments, you'll also see my phone number. It's 561-405-4889. Go ahead, call that number if you'd like to speak to staff. You'll get the scheduling coordinators who will then put you on my schedule so we can talk. Okay, so you filed June 10th, no receipt notice yet. And that's now it takes a while to get that receipt notice. So don't panic yet, because it does take a while. It's very normal right now for the receipt notices to be backed up for the VAWA applications. So I wouldn't panic. Just yet. Just hang tight, and you'll see. As long as you properly filed your petition, you'll probably see that receipt notice. What you always need to do is make sure you keep a copy of the application, and make sure that you deliver it by. Make sure it's trackable. Whatever, if you use a courier or the US mail, just make sure that you are able to get confirmation that it was delivered. That's going to give you some reassurance, because it will be signed off by an officer. So you can see that an officer has signed it and taken it. That way, you know that it's there. And if it takes a little while, then they're probably just a little backed up. So that's one tip. Don't just drop it in the mail and say, oh, well, good luck. We make sure we can track all of our clients' packages to make sure it got there. All right. So, what if a person got divorced because of an abusive spouse early this year and want to marry someone else to bring them to the state? Would there be a problem to remarry and file the person? So it may be. So definitely, if you are a permanent resident and you received your permanent residence, from another permanent resident or a citizen, and it's been less than 5 years since you got the permanent residence, then yes, then you remarry somebody else, you can't file for them. Well, if you do, it's just going to possibly open up a can of worms, because they are supposed to deny. So the Immigration Service must deny the application if the permanent resident who just got their permanent residence within the last 5 years has divorced that spouse who they got the residence from and has remarried somebody else within that 5 years and is now trying to file for them. They have to deny it unless that couple can show by clear and convincing evidence that the current marriage, as well as the previous marriage, is real, are real. Clear and convincing evidence is a very, very high standard. That means like as close to certainty as you can get, right? And based on that standard, it's more than likely you're going to be denied, right? So I in that case, most attorneys will tell you it's not worth it to go ahead and file for someone else within the last 5 years. Now, if you become a US citizen, then sure, you can go ahead and file for someone else as a citizen, but then you're going to face that higher standard. And you know, it can end, they can even open up a whole investigation if they find that you married someone, divorced them, then remarried someone within a short period of time, file for them. They are going to open up that file, open up the previous files, and before you know it, you could be slapped with, even though it may not be true, you may be slapped with a marriage fraud accusation that you have to fight. So, in a nutshell, you know, you have to be very careful about remarrying after getting your green card and then refiling for someone else shortly thereafter. Can I add the child to my VAWA application after I get approval? Or do I have to do it while the VAWA application is pending? So the VAWA application asks who your children are. And if you don't put your children on that VAWA application, you need to make sure that you make that correction to add them to the application so that they show as derivatives. You can, after you get approved, you can also add them there because they qualify. They're going to qualify through you as long as they are under 21. So this is where it's important. You just want to make sure that they have protection. They don't age out. So you want to add them to the petition as early as possible to make sure that they're not going to age out, and that they are on the petition with you. So I would say it doesn't hurt to, you're supposed to disclose your children anyway. So they're supposed to be listed anyway. So, but if for some reason you didn't put those children on your I-360, then you need to make sure you add them. Inform the Immigration Service that you do have derivatives children that need to be included on the I-360 as well. So they are on the I-360, but you haven't submitted any I-485. So with the children, you're not going to submit an I-485 for the children until you're approved. So once you're approved and they're here with you in the US, then you can, everybody will have that VAWA status and be able to adjust status to permanent residence. So I need to apply for the green card. Give us a call. Let's talk about how you qualify for the green card because there are a number of ways. The last I checked, I'm pretty sure there's many ways, but the last I checked, there are 21 common ways to get your green card. I'm not even talking about the other types of unusual ways that you can get your green card. There are 21 ways, right? Over 21 ways. So, as you can see, in a case where you want to apply for your green card, we have to do an evaluation to determine whether you qualify through employment, through family, through humanitarian ways, like if you received asylum, if you received the T visa, if you received the U visa already, and now you're ready to apply for that, if you receive VAWA, if you qualify for VAWA. So schedule that appointment. It's worth doing it to see if you qualify in any way. If I apply for VAWA, can I apply for a visitor visa for my child in another country? So yes, but keep in mind it depends on what the officer is looking at and what the circumstances are. And I'm talking about the officer at the embassy. Um, you know, you it, if getting VAWA or applying for VAWA is not going to entitle your child to the visitor's visa. So it's not going to be an advantage. And you being here it may be something that you have to disclose on the application that you're here in the US, and they may see that as a tie, that you are a tie to your child. So it's one less tie to Jamaica that your child has, because if you're here, then what's keeping your child in your country? So, it's not visitor's visa is completely different from VAWA. It's not really connected. There's no real connection, and it depends on what's disclosed on the visitor's visa application. But VAWA is not going to be a benefit for your child to get a visitor's visa. Once you get approved, then your child, and you get your permanent residence, your child will be able to come up on an immigrant visa based on that approved VAWA. All right, so I received my prima facie and advance parole. How long will it take for my VAWA approval? So right now it's taking about 2.5 years to 3 years to get that VAWA approval. What happens is, in between, you do get your work permit and your travel document that keeps you settled and allows you to move forward with life until you can get your VAWA approved. All right, I don't see any more questions, so I'm going to head out today. So it's good to see you again. Good to be back. Good to be making it on time. I will see you tomorrow at around lunchtime to talk to you about another topic. And you can come with your questions. And as soon as I finish talking about my topic, we'll jump straight into your questions. So, as again, to get in touch with me, go to the link in the profile. Link in profile is on Facebook, YouTube, and Twitch in the description of the video. And then here on Instagram, if you go to the link on the profile page or the bio page, you'll see the link. Go there, it's Linktree, and you'll see a number of links to access different resources, which is the website. You can schedule your own appointment, or you can even see other guides to the marriage-based interview process, and to subscribe if you want regular um, information or updates about immigration from me. All right. So I'm looking forward to speaking with you. Make sure you get it done ASAP so I can get to talk to you, because my schedule is filling up and I do want to make sure I can help you. All right. Have a good day. See you tomorrow at around lunchtime. Bye bye.